Hi there, this is Erica Merrill, and I'm the founder of Perfect Legal Video. And I am very excited to have with us today, as usual, attorney Nicole Reeves of Lavallee. She owns a family law practice out of Worcester, and she's just amazing. And today we are going to be talking about a brand new topic, and it is conciliation. So, welcome, Nicole, to the show. Thank you so much for joining us.
Thank you for having me.
You're welcome. Now, conciliation, let's get a definition for this for those of the audience that don't know what it is.
Conciliation is a form of ADR, so as alternative dispute resolution. It's a way where you can go and sit with the other party and try to resolve the issues. It is different than mediation and it is different than arbitration. It's another form that is specific to certain areas of practice.
So, what types of cases are we talking about here?
So conciliation is offered in superior court, in district court, as well as probate and family court. So you could have a breach of contract, you could have a landlord tenant dispute, you could have negligence claims, and of course you can have the all encompassing family and probate, which is divorces, adoptions, guardianships, and all those good things. So it does have a wide range of areas that people can conciliate in.
So, is there a certain process that we need to follow if we would like to have a conciliation?
In almost all the courts, you're going to need to request it from the judge. The judge will automatically grant it. If both parties want it, it will be granted. It's kind of done administratively, except it is a court order that you go to mediation or conciliation. I will say that they will ask both parties. And if one person says no, then it's no. Because again, this is a voluntary process, and both parties have to be willing to sit down to try to negotiate a settlement in their case. So once the court orders conciliation, then depending on which court you're in, you may go to the conciliator immediately that same day, within minutes, or it would be at a later date. So if you're in district court or superior court, you probably already have a hearing that day. You may even very well have a trial that day. So you're going to go into conciliation immediately as soon as the judge orders it, try to resolve it in conciliation. And then if you don't, later that day, you'll have a trial. On the other hand, in probate court, you'll get assigned a conciliator and they'll run you through the program to figure out who's available to conciliate. And that will be at a later date before your next court date.
Well, I mean, it sounds like that'll make things a lot easier on everyone. How long does a conciliation process typically last?
Well, conciliators, while appointed, are doing it pro bono. So it really depends on how much time they have, and how many people are waiting. Again, if you're in district court or superior court, they might have 2 to 3 cases to conciliate that day. Obviously, they're not going to be able to devote a lot of time, maybe 30 to 45 minutes. If they don't have another case and they don't really have anything going on that afternoon or that later that day, maybe they'll be willing to do it for an hour or two. In probate court, really kind of depends on the conciliator. I always plan on 2 hours to conciliation. And then generally speaking, the conciliator will offer, if you guys have not reached an agreement, you want to come back at a later point in time, feel free to reach out to me and I'll do a little bit more. So probate and family court, we really try to extend the olive branch even more than is necessary just to get the parties to a full resolution.
So, what happens in a conciliation? Is it a lot like a mediation?
Similar. So the biggest thing with conciliation is it is confidential in the fact that the other parties don't necessarily need to know what's going on. The judge doesn't need to know what's going on. But the conciliator will write a report saying they resolved X, Y, and Z, but A, B, and C are still outstanding. In probate court, they actually will give you a little bit more insight. Like they'll say, hey, I know you're going in front of Judge Blank, and this judge is probably going to rule this way based off of all the evidence or whatever's happening in your case. Or I just had this case the other day. We also are allowed to reach out to the judge to kind of give a little insight as to what that judge would be thinking, if we're on the right track or not. So you certainly get a lot for your money, especially since, again, it's a free thing that is being offered to you just so you can resolve it and not take up more of the court's time. But generally, like I said, that's kind of how conciliation works, that you have that level of confidentiality to a certain degree. But you sit down, you negotiate, you talk with both parties individually and together. A lot of times in conciliation with divorces, sometimes the attorneys are booted out of the room, and then you're only dealing with the parties, because sometimes attorneys do get in the way. So it really depends on what that conciliator feels, how they're thinking that parties are going to resolve things. A conciliator is really good because, again, they're not neutral. They're allowed to say, the law says this. What is your basis? How do you think you're going to win this? So it is a little bit of a reality check where, again, a person in the robe says the same thing. Now a conciliator says the same thing. You start believing that, hey, maybe what my attorney was telling me all this time is the right thing, and maybe I should negotiate. So the conciliators are very forthright in terms of what they think the judge is going to do, how they think the law is going to play out in their particular case. So it's certainly something that you need to take. You need to listen to it, you need to understand it, and you need to decide whether or not you're going to take that basically free advice, and try to resolve it, or if you're going to dig your heels in.
Well, that makes a lot of sense. So, I mean, I feel like this happens sometimes, where you sit down and you try to work things out and you just get stuck on something and you can't reach an agreement. What happens if that is part of your process with the conciliation?
Well, I think with any conciliation, you may not resolve all issues, but the question is, did you come a little closer? Did you get an understanding of what the other party's position is? Do you understand why they're saying what they want? And were you able to resolve one or 2 points? Those are all things that are very helpful. And at the end of the day, guess what? You can still go to the judge on whatever remains outstanding. Maybe you resolved one of the hardest issues, um, and that you have another issue that just is a 10-minute oral argument to the judge. And the judge is going to give you insight, and maybe you go outside and in the courthouse and resolve it that way. So there's a lot of things that can happen. At the end of the day, again, you do have your right to your day in court. You're not going to lose anything but a little bit of time. And from my perspective, why would you not take advantage of a free service with legal advice?
I mean, that makes a lot of sense. And if you can work it out, then what do you have to lose?
Exactly. You lose a little bit of time, but you gain a lot of knowledge, because what if nothing else, you're going to learn that information about why that person is thinking that way. And again, the conciliator is going to give you brainstorming ideas. So maybe what you were thinking about wasn't the best way to do it, but maybe there's another solution. And maybe you disagree with the numbers that the conciliator came up with, but again, it's a different idea. So now you can start using that to your advantage to maybe tweak it to your liking.
I mean, I think this is great advice, and it's certainly less expensive, I would think, than going through a whole trial.
That is an understatement of the year. Conciliation, again, you're probably looking at 2 hours of time. Yes, you're still paying for your attorney, but I don't know any trials that are going to be done that quickly, because behind every trial is at least twice that amount of time in prep.
Well, that makes a lot of sense. And, we really appreciate your bringing this information on conciliation. I don't think it's something that you hear about as much as you hear mediation. I mean, I don't think it's a word that is as common to the public. So this is really a great bit of information. And, we appreciate you coming here and telling us about these things on a Friday afternoon. And I want to thank everyone for watching. And if you are in need of help from a family attorney or a real estate attorney, Nicole's office can handle both. And they're amazing at it. They stay on top of all of the changes in the law, they stay on top of the strategies, and they make sure that they get their clients the best outcome. And so don't hesitate to pick up the phone or the call. They're very nice people and they're great at what they do. So thank you so much, Nicole, for joining us today.
Thank you. It was a pleasure.
Okay. Have a great afternoon, everyone.